Evening, everyone. I am Lisa Morgan, President of the Georgia Association of Educators. Thank you for joining us this evening for our next Rights at Night session. This evening, we are going to be learning more about our rights and our responsibilities in some cases with federal issues with our students in special education, with 504 plans, and then our employee rights with Americans with Disabilities Act as well. So at this time, I'm going to turn it over to our GAE General Counsel, Mike McGonigal, who will introduce our guest for the evening. Mike?
Thank you, President Morgan, and good evening, everybody. Just a few words of introduction to a great friend of GAE, Craig Goodmart. Craig has been an attorney for over 20 years and has been at GAE's side representing GAE members throughout his career. Tonight, we're very lucky to have him. He's a recognized expert in special education law, First Amendment law, and employment matters. And tonight, Craig is going to share some slides and take some questions regarding special education law and COVID, employment law and COVID, and then he's going to dive into, and we're going to let Craig brag because Craig is deeply involved in our federal litigation, our school reopening lawsuit, and Craig, and some other litigation that we have going on as well against some other school districts here in Georgia. So with that, again, we're deeply honored. Craig, thank you for your time and take it away.
I'll do it. Thanks so much, Mike. Thank you, Lisa. I'm really excited to be here. I think this is my second GAE Rights at Night presentation. The first one, I believe, we talked more about special education, and we're going to do that again tonight. We had such a great response. Lisa, how's my sound?
You are good, but I messed up and forgot to tell everyone if they have a question to put it in the chat, and we'll make sure to answer all their questions.
We'll do it. So good. I'm glad my sound's coming through. As Lisa said, I'm happy to answer questions that you may have. We will do it as we go along. Lisa will stop me to ask the question if it's an opportune time. If you do have a very specific question that involves, information that you may not care to discuss in front of others, hold on to that and just email GAE Legal Services, and hopefully we can get you to somebody that can answer that question for you. Today we're going to talk about special education. It's something that I have, I get very excited about. I'm very passionate about it. I represent both teachers and families in special education proceedings. One of the first things I ever did was represent a teacher who had to testify at an administrative due process hearing up in North Georgia. And you may be wondering, well, why does that teacher need a lawyer? Well, that teacher actually wanted to come forward and talk about what the school's position, what was the problem with the school's position. And the school didn't want her to do that, but the teacher asserted her right to be able to testify honestly, and GAE supported her in that. And so we went on up to northwest Georgia, up into the mountains, and that teacher had her opportunity to tell the truth with a GAE lawyer by her side. And so sometimes it can be a very emotional process. It can be a process that can be adversarial at times. But at the heart of it, everyone generally is there to make sure that a child, a student of yours, is getting the services that they need to be successful in school, and that serves everyone. So tonight we're going to talk more about special education and specifically the impact that COVID has had on the special education process. We're going to talk a little bit about the Americans with Disabilities Act and the impact COVID has had on the interactions between employees and employers in the school context. And then we'll talk a little bit about the litigation that GAE has been involved with, and I've been lucky enough to be a part of, working with some amazing lawyers from the national office at NEA and some Georgia lawyers here in trying to put out what I think is the most cogent and compelling argument that we've heard yet about why schools should be embracing the CDC guidelines before they subject teachers to the dangers of providing instruction in a classroom that may be exposed to COVID. So I'm going to share my screen, hopefully successfully. How's that look, Lisa?
We're good.
Perfect. So GAE Rights at Nights, Federal Education Laws and COVID's Impact. Again, I'm Craig Goodmark. I'm down here in Atlanta. If I say something that's Atlanta-centric, I apologize. I know that we have teachers from all over the state, that GAE has members all the way down in Valdosta, where I've gone down and helped some teachers, all the way up in Augusta and over in Columbus. Understand that as GAE does, that Atlanta may think it's the center of the universe, but there are way more teachers out there from all over Georgia, and I know that. So I apologize in advance if I seem Atlanta centric. Wanted to start with a slide that Mike puts up generally during his talks, because I think it's important for everybody to know that GAE Legal Services is a benefit of GAE membership. It provides you employment liability protection with up to $1 million of liability and $3 million in aggregate. And it's the same for your attorney's fees and costs. It provides you defense for your job. It provides you defense for your certification. There is no predetermined cap on legal fees like some other organizations. Many defense cases will exceed $10,000 due to appeals. And we have, and myself have participated in affirmative lawsuits that cost organization quite a bit of money to support, but in the end was the right thing to do. And we were able to get good results for teachers who had been treated unfairly by their school district employers. We have expended millions of dollars protecting jobs and winning pay and expanding our educator rights. And we have done big cases, and then I'll take a second to brag. And we've done discrete things. Just recently, we were able to successfully represent a teacher in South Georgia on a certification upgrade denial. The teacher had some very interesting facts that led to the PSC denying his certification upgrade, even though he had completed the education necessary to achieve that. He had gotten the PhD. But the circumstances were really weird, and they denied him. GAE Legal Services assigned a lawyer to the case. It was me. I was able to, get involved, advocate on behalf of the educator, and we were able to secure a positive outcome for that teacher relatively quickly. And I was very pleased to be able to help out in that. Something that's as discreet as a certification upgrade. It doesn't seem like that big major of a victory, but it's that type of support that GAE Legal Services provides to its members that makes the difference, and it certainly made the difference to my client. Yikes, I've lost the ability to change. There we go. Tonight, as I talked about, we are going to be talking about special education pursuant to the legal principles. And what you need to know right off the bat: special education is intact, even if it's remote, just as your employee rights under the Americans with Disability are intact, even though it may not feel like it. And I know a lot of us have experiences of asking for a reasonable accommodation, which is a concept that exists because of the Americans with Disabilities Act, and have been outright denied. And there have been stories of blanket denials by districts. And so it may not feel like the ADA is intact, but it certainly is intact. And there has been no waiver of ADA rights granted by any federal authority that I'm aware of. And the GAE and NEA are working to address the inequities and injustices that exist in the public schools, and they are fighting hard. And let me see, I got to do some housekeeping here as we go. Some of the guiding principles that surround COVID-19 in schools that related or that impacted the decisions on when to open and how to open really are interesting to me. And I've talked about this in the past, and it really is this interplay of national and local pressures, political pressures. Then you have kind of the intersection of health, of education, and then of law. And all of these things work together to create these circumstances that teachers are essentially thrown into the middle of. Certainly, as a classroom teacher, we didn't get to say as to when a school would reopen. And as a classroom teacher, we didn't get to say as to what precautions would be put in place. All these things have happened outside or surrounding us, almost like a tornado of policy and decision making. And we are left almost helpless to be kind of pushed and blown around to see where we land. But some of the principles that were in play when they were talking, when the decision makers were deciding how to reopen, were that you have to reopen schools. And that's one of the things that the community and the CDC said, is that schools don't just provide education, but they provide other critical community services, meal programs, physical, behavioral, mental health services, because they come through the school to our children. And so there was an incentive or a motivation there to try to reopen schools. But at the same time, what we couldn't do was reopen a school and expose people to health risks. And so even though the CDC called on their communities to reopen the schools, there was still that very real risk. And while the risk now has gone down because of current events and circumstances, the risk still exists. Those two ideas, there's a risk and that we need to open schools, also were impacted by the fact, and you may have heard this in the past, that in Georgia, decision-making, and specifically school district decision-making, is exclusively local. And I use those words intentionally because school districts are empowered through the Georgia Constitution to operate and manage their own systems. And so school districts rely on that when they are challenged in their decision making, and they are able to use that concept, that constitutional concept of local control, as a sword, saying that we're going to do this because we have the authority to do this. And they are doing that, just that when it comes to making decisions about COVID. They're saying we are locally controlled. There is no authority above us telling us one way or the other what to do. And so we'll make our decisions based on the policies that our Board of Education has created and in the practices that we are going to follow locally. And so you have the local control, even though these competing and very real, interests or concepts of getting your schools open to help your community and minimizing risk still exist. And so those are the guiding principles. That's what's happening as this decision about when to reopen a school is being made. There we go. The same idea was in play when the Georgia Department of Education started making or publishing guidance about how we're going to provide special education services to students. The idea that we need to reopen so that we can provide special education services to our vulnerable population of kids with disabilities, but there's still a health risk there. Different than general education or regular education or school-wide decision-making, because there is a federal law right on point, the Individuals with Disabilities Education Act, the Georgia Department of Education, I think, essentially empowered themselves after receiving directives from the U.S. Department of Education to provide some guidance. And this is very specific guidance. I think comparing it to the guidance that they've gotten from the Georgia Department of Education on COVID reopenings in general, this was very, I think, helpful to practitioners and educators in the field, but an affirmative statement saying, this is the way that we want this to happen. And it happened first in, I believe, May, and then there was a subsequent guidance issued in July, and I have it cited there, July 30th, 2020. And generally what it said was that even though we have all these things going on, even though kids are being provided virtual instruction and not in-person instruction, when it comes to special education, all of our IDEA timelines are intact. And when it comes to special education and the students' educational services, their right to a free, appropriate public education is intact. There is no waiver, there is no carve out or condition that says, well, yeah, it's COVID, so you don't have to do it. That did not exist. That there was language on the federal level being discussed about perhaps waiving IDEA, some of IDEA's requirements, and providing essentially an amnesty or providing a safe space for schools so that they wouldn't have to provide these types of services in the throes of a pandemic. But those were rejected. And so we have an affirmative statement by first the federal government and then our Georgia Department of Education that IDEA is intact. Students' IEPs must be implemented as they were written. And so what were schools left to do if you have a non-face-to-face situation, but face-to-face services being required by the law? And that was how we developed, or that was how the virtual distance and remote learning plans came to be. Is this was the response to how do we provide special education? For example, if a child receives ABA services that are hand over hand, how could we do that in a virtual setting? And the school districts were told by the Georgia Department of Education, you don't have an excuse, but you can create remote learning plans or distance learning plans in order to identify those services that cannot be provided, and then create a plan for what you are going to do now and reserve or hold off to the side that which you cannot do now. And for that bucket of services that were not going to be provided because of the circumstances, the State Department of Education said compensatory education may be appropriate. And we'll talk a little bit about that coming up in a little bit. But
Craig, we have a question that relates to that.
Go ahead.
How does strategic waivers, and I assume you're familiar with the strategic waiver system, give the state of Georgia the right to overcrowd resource classes? More specifically, what is, quote, small group if a county can put as many as 16 students in a trailer with no support?
Okay. Interesting question. Impact special education in as far as you have a resource cost, and so those are special education students in that class. But I will say the short answer is when you waive, or when you become a strategic waiver district, you have waived all of the laws, all of the rules, all of the policies that exist regarding public education and replace them with your own set of rules. The only limitation on that is that you cannot waive out of the federal laws and you cannot waive laws related to the civil rights of people. And so those would be the Civil Rights Act of 1964. That would be IDEA as it stands. That would be the ADA in Section 504, which provides that, which requires access to education. But in this, it's actually a very complicated question. Class size is a general education rule that can be waived. And in fact, it was either, I believe it was the recession, when the recession of 2009 hit and our state had financial crises, those class sizes were already waived. And the concern back then was that, well, if we let them waive class sizes now, they'll never go back and put class size restrictions in. And in fact, you know, we haven't had true class size restrictions, even though it's on the books. All schools have been able to waive out of class size restrictions if they've opted into that. So they can waive out of class size restrictions. What you can't do is create a classroom so crowded that a student can't receive the educational services in their IEP. And so while it's not a per se violation to have a large class, I would say that if a child is not getting access to their educational services, or there is another rule that exists that limits somewhere the size of a class, then I think the schools would have a problem. So the reality is that these classes get very crowded very quickly. And when people come looking, miraculously the classes become smaller. But I would say that first and foremost, you cannot create a situation where a child can't receive their special education services. And if there is no waiver of that special education rule, then you can't overcrowd a resource classroom. So that would be my answer. Wanted to take a quick minute. People seem to respond to this, and I always think it's helpful because we're going to talk about special education. We've already started with remote learning plans and IEPs to remind people that when I think about IDEA, I think of it as a process that's divided into 4 main areas. And those 4 main areas are identification, evaluation, eligibility, and placement. And so while special education can be very complex, generally speaking, we can break it down into this 4-step process that starts with identification and then finishes with placement. Identification is child find. It's the requirement or affirmative obligation on a school district to identify, locate, and evaluate all students that are suspected of having a disability. Once all of those children, all of those students are all the students are screened using our pyramid of interventions, those students who are not successful using standard-based grading, standard-based instruction, those would be identified for student support team instruction and moved up the pyramid of interventions until they would be referred for evaluation. And evaluation is the 2nd step in the process. Evaluations are the execution of a multidisciplinary evaluation in all areas of suspected disability. And this step in the process is a requirement on school districts to look at the whole child, look at all of the disciplines in education, not just academics, not simply just taking an IQ score and some achievement scores, but all of the disciplines, including physical therapy, occupational therapy, speech language therapy, whether or not a child is hearing impaired, or whether or not a child has behavior challenges, all of those disciplines to create a multidisciplinary evaluation that identifies the student's needs and then determines whether or not those needs require interventions. If once that evaluation is complete, and the evaluations will really drive the next 2 steps in this process. If the evaluations are limited, if the evaluations are narrow or poorly executed, well, then the next 2 steps aren't going to be completed with any kind of accuracy. So it's really important that we have good evaluations so that we can have get the correct outcome or correct decision when it comes to eligibility and placement. Evaluations, once completed, it is required that an IEP team or an eligibility team convene within 60 days of the date that a parent signs consent for evaluation to determine the student's eligibility and then create an IEP, essentially placement, if the student is eligible. Eligibility is that stage in the process where we say, yes, the student is in need of special education services, or no, the student is either 1, not disabled, or 2, is disabled but doesn't need special education services. And if a student is disabled and requires special education services, we confer eligibility through one of 13 categories under IDEA. And these are familiar to those people that work in this process. Categories like other health impaired, or emotional behavior disorder, or specific learning disability. Those are categories of eligibility. And it's important to remember that a category of eligibility doesn't dictate the service that a student will get. It's simply a statistical counting of the students that are coming into special education, so we can know who's being identified for what. You may have read that there are instances of over-identification where some students are improperly or inappropriately identified for a specific learning disability when in fact they just have a limited knowledge base, and there's measures or procedures taken to guard against over-identification, just as there's procedures for under-identification where particular disabilities may not be evaluated fully, and then we don't come to the answer that the child is disabled in that area. But eligibility is just a statistical category. But once you're eligible, you move into special education services and placement, and that's done through the creation of an IEP or individualized education plan at an IEP meeting. There are several components to an IEP. I won't go into all of them tonight, but what's important for our discussion tonight is that IEPs will identify instruction, and they will identify services, and then they will identify where on the placement continuum will this bundle of instruction and services be provided. It's that instruction and those services which are the subject of the creation of remote learning plans or distance learning plans as a result of COVID, because how can we provide the instruction if we can't be face-to-face? Is there a limitation there, and what do we need to do about it? The timelines that I referenced before that are still intact, what timelines exist under IDEA? Well, as I stated, initial evaluations must be completed, and an eligibility team has to convene within 60 days of the parent's signature on a consent or the parent signing a consent for an evaluation. And so that's 2 months. And that's a hard rule. That rule doesn't move. There are some limitations or some conditions for summer and for school breaks, but 60 days is a time frame that is listed in IDEA or contained in IDEA. It's not a state rule. It is mandated by the federal IDEA regulations. The second timeline that's still intact is that eligibility must be determined within 10 calendar days after the evaluation is complete. And so you get 60 days to do your evaluation, but from there you got to get to that meeting also within the 60-day window, but within 10 days of having that evaluation completed. Initial IEPs have to be created within 30 days of the eligibility, still in that 60-day window. And then IEPs must be in effect at the beginning of every school year. Those timelines are still intact. Those timelines have not been waived in any way by Georgia or the federal government. So is COVID an excuse? No, immediately. So look at the date here. This is what's so telling about our response. On March 21st, which is 1 week after Fulton County schools shut down, and really almost all of Georgia shut down, the statement from the U.S. Department of Education was that school districts must provide FAPE consistent with the need to protect the health and safety of students with disabilities. And so there was a clear statement by the Department of Education, Federal Department of Education, that said, you got to provide FAPE, even if it means that it may not look like what it looked before our shutdown. You still have an obligation to provide those services. And so that's how we got to the development of remote or distance plans. And so it takes many different forms across our state. It's been called virtual, it's been called distance. It has its own acronyms and its own procedures, because there is no standardized way to create a distance learning plan. And really, for IEP planning, it all depends on the kid. It's going to depend on the services that are in a child's IEP. For kids that are, for example, very severely disabled with hearing and vision impairments, those kids, they have very little opportunity for remote instruction. There needs to be in-person learning, and for the time that there was distance learning in place, those children didn't receive much instruction. But the first bullet here, if distance learning is in place, and that means if the school is not providing face-to-face instruction, then distance learning plans would have been developed. What is important about that is that a distance learning plan amends the IEP, and it amends the IEP to include whatever type of instruction is going to be provided. And so it's essentially a change in your IEP. And anytime there's a change in your IEP, you have to provide notice to the family. You have to give the student's family an opportunity to participate in that discussion. And the student's rights to disagree with that change also exist. Distance learning plans didn't replace an IEP or the IEP process. It simply was an amendment to the IEP. It's as if we went from going from, a January IEP that provided 6 hours of instruction to a April IEP that provided 2 hours of in-person instruction and 4 hours of remote instruction. We simply amended the IEP. It changed what services and instruction were provided. So that begs our question, and it is the question that's absolutely coming to everybody's mind now, which is, well, what do you do with the services that weren't provided? What do you do for the delay? Because lots of districts didn't come back online in a very real way until August. There was lots of communities where children's services weren't put back in place in March and April, and school ended, remember, at the end of May. And so you have a good slice of our population who didn't receive any services. And what did the law say about that situation? Well, when IEP services are delayed or denied, a student is entitled to compensatory education services. Compensatory services is a concept that is originally created as a remedy in a litigation context or in a context of a due process hearing, or when there is a dispute among the parties as to whether or not special education was appropriately provided. And so it didn't fit exactly in this situation, because in this situation, we didn't have a dispute. We simply had a circumstance where education services weren't provided. One party wasn't saying we did, and the other party was saying we didn't. We have both parties saying, no, it didn't happen. And so the federal government, Federal Department of Education in Georgia used this concept of compensatory education services to address, which comes from disputes, to address something that isn't a dispute. And so it doesn't fit on all fours, but it's the best we have. And so that's what we've gone with. And compensatory in the case law that has developed about it over the years, again, about disputes where compensatory is awarded, means services necessary to close the achievement gap created by the denial of FAPE. And so in a traditional circumstance where a family has alleged that a student hasn't received appropriate instruction, you would have this idea of, well, had he gotten everything or she gotten everything that was in the IEP, they would have been here, but they're here. And so that gap is called an achievement gap that needs to be addressed with compensatory education services. That's the concept. But when we don't have that dispute, we don't have two parties saying, what they were saying, we have a circumstance where everybody says, well, we didn't do it. What should we do? The U.S. Department of Education said in that circumstance, the child's IEP team, as opposed to an administrative law judge or as opposed to a U.S. district court judge, determines compensatory services. And then this is the standard. And unlike the standard under the disputes, which says services necessary to close the achievement gap, the standard is services to make up for any skills that may have been lost. Certainly a lower standard to show. We don't have to prove an achievement gap at an IEP table, because again, this happens at the IEP table. We just have to be able to say, these are skills that may have been lost. Third grade student in March of 2020 was going to be finishing his reading fluency. If things were going to plan, third graders finish learning to read in third grade, and then they move on to reading to learn. And so if you didn't get that third grade curriculum from March until June, those skills that may have been lost are likely reading comprehension skills, reading fluency skills, if we're guessing. And so we would say, well, let's get him some reading instruction because those are skills that may have been lost. And at an IEP meeting, that would be the discussion. Of course, it's all individualized. We look at what instruction and services were in the IEP, what was provided and what wasn't, and then what skills would be lost as a result of not providing those services. If a child receives speech language therapy and they were supposed to have 2 sessions of speech language therapy from March until June, well, it's very likely that the goals and objectives that address speech and language in the IEP are skills, would have been skills they would have acquired in that time. Well, those are skills that would have been lost. And the compensatory educational service that the IEP team would determine would be likely addressing that speech language therapy to make up for that skill. Lisa?
Yes, we have a question. Can teachers be held liable if a parent chose online education for their special needs student, but now the parent claims the teacher did not effectively provide services and accommodations?
Well, let me start with the premise of the question, because I really feel like this is misinformation that I really want to get out there. Generally speaking, teachers are not liable individually for the failure to provide special education services. They are working at the direction of their supervisors in the context of a district. And generally speaking, the type of liability that it seems like you're asking about is about a damages-based liability. And I will say the damages generally aren't available and usually aren't available from teachers for misdeeds or for the failure to provide the services like the parent is alleging. So let's all take an exhale and say, okay, I'm not getting sued for my interactions with this parent based on that hypothetical. Now let's talk about that circumstance. So the parent is allowed to waive special education. They're allowed to withdraw their consent. They're allowed to say, I don't want the services because I don't want you coming to my home, or I don't want to access the computer. They absolutely can do that. Once they do that, they don't have the right then to come back and allege that there was a denial of FAPE. They've waived that because they've withdrawn their consent. And so the answer would be no. What it sounds like you have is a parent who had changed their mind and wants to misremember or recreate history. And always GAE Legal Services gives teachers the advice that when you're engaged with that type of interaction, it's very helpful to keep a record. If somebody had called you and said something, you want to write that down, or you want to send an email back to that parent that says, just confirming that you no longer are wishing to access special education remote learning. Please let us know when you're again going to access remote learning. Always put things in writing. If you feel vulnerable, the best way to protect yourself from somebody claiming you did something is to document what you did right when you did it. And that's the best advice GAE Legal Services will give you, and it's consistent across the board. It goes to any circumstance. Doing your lesson plans, engaging special education, asking for time off, or sending kids down to the administrator. Write down what you did, and then send somebody communication to document your decision so that you aren't later having to hold yourself to a different narrative, having to prove a different narrative, excuse me. So that is FAPE, delayed or denied. I think we're going to have a lot of disagreements about compensatory services. As teachers, I think it's super important to make your decisions at the IEP table based on the evaluations that exist and the data that's been collected. It's always good practice to really play close to the data. And if there isn't data, you want to talk to the team about, well, maybe we need to take a little data before we answer this question, either through probes, individual assessment, or standardized assessment. So that's how I would address those circumstances. But understand that this is coming because everybody deferred decisions about these remote services till we all went back face to face. And here we are, we're coming back face to face. I expect we're going to have a deluge of requests for compensatory services upon school districts comes extended school year, which is special education in the summer. Anything else?
Nope, that's it.
So we'll move on. We're getting pretty long here. We're 7:10, and I want to make sure we cover the second part of our talk. And then, of course, I want to make sure I get to brag. COVID and the ADA. The Americans with Disabilities Act, as it applies to employees and public employees like teachers, says that their public agencies like school districts can't discriminate against workers on the basis of disability. It also says that you have to allow employees access to their employment opportunities if they have disabilities. And so that's why we get one, you can't discriminate. You can't just go out and treat somebody differently on the basis of their disability. And two, you have to accommodate somebody's disability to ensure they have an equal opportunity to that employment, to the benefits of that employment. And so when it comes to the ADA, you have those two guarantees as an employee with a disability. The ADA only covers eligible employees, that is people with disabilities. And unlike in special education where you have to make a higher showing of your eligibility, meaning that you're not just disabled, but you also need something like unique and individualized instruction. Under the ADA, you need only show that you are a person with a qualified individual with a disability, either one, that you actually have that disability, two, that there's a record of that disability, or three, that you're actually regarded as a person with a disability. When it comes to COVID, the essential components of the ADA are intact. And I said in the beginning, it doesn't feel that way because of all of the responses that we've heard about employers not honoring accommodation requests. But it is intact, and you can't be treated differently on the basis of your disability. Circumstances related to COVID-19 that are unique and may feel a little different to us include allowing employers greater access to medical information that's related to pandemics. And let me note there, that's medical information related to pandemics. And so while the ADA is not going to say employers can't dive into whether or not you've been exposed to COVID, whether or not you have antibodies, whether or not your temperature is high, or whether or not you're exhibiting symptoms of COVID, they still cannot just gain unfettered access to private medical information for no reason, okay? The ADA prohibits that. The ADA, there also have been circumstances that related to COVID-19, allowing employers to administer medical tests as a condition of on-site work. And the first one, and an obvious one that we're referencing, is taking people's temperatures. And certainly the ADA does not protect or prohibit the taking of temperatures of employees for pandemic-related reasons. Again, not any reason, not just because we want to, or maybe we're going to create some arbitrary cut line and then keep employees that don't make it off-site, but it has to be related to the pandemic. And the last COVID-related circumstance has been requiring employees to meet certain health conditions before entering the workplace. And again, these are intuitive. These are things that generally are not controversial. Employees don't want to be in a workspace where other employees are exhibiting symptoms of COVID. And two, as part of this community, we all agree that we are going to do what we can to maintain a safe working environment. The most controversial piece of the ADA that's come up during COVID is the reasonable accommodation. Under the ADA, an employer must make reasonable accommodations to qualified individuals who are employees or applicants, unless doing so would cause an undue hardship. And of course, that condition there at the end of the definition really, for our purposes, has swallowed the whole rule. Undue hardship and causing undue hardship has been the fail-safe for the school districts to be able to deny the accommodations that employees have been seeking. During COVID, educators were seeking to remain at home as an accommodation because of medical vulnerability. And essentially, the schools have to provide that accommodation. If you're a qualified individual, if it's ensuring access to the work environment and it doesn't cause an undue hardship. And of course, that last bullet, that third element there, is where schools say, yeah, but I can't give everybody an accommodation to stay home because I have students coming into the building and we have to provide the instruction. And so schools are saying, I've got an undue hardship. Well, what is an undue hardship under the law? The undue hardship is defined as a significant difficulty or expense based on the following factors. One, the cost, based on the net cost of the employee, the financial resources available, the type of operation, and that's where schools are able to say, well, I need teachers to teach students, and the impact of the accommodation on the operation. Again, if I have to give this accommodation across the board, I won't have anybody in the building. And I haven't been involved in any ADA COVID-related accommodation cases yet, but I expect that the school districts are saying it is simply an undue hardship on us to grant these accommodations. And so we are taking the position that we don't make this accommodation. So that leaves teachers in a terrible position. Teachers, specifically in counties where the CDC safety guidelines have not been followed, are saying, well, I don't want to go back into the building if you're not going to require masks. And school districts are saying, we don't have to require masks and we're not going to do that. My advice in circumstances like that, unfortunately, is not as helpful as I want it to be. You have a job and you have responsibilities and duties. And if you're given a directive, then you have to follow the directive or suffer the consequence of being, cited for some form of insubordination or a willful neglect of duties. And like I give advice to clients all the time, you may have a lawsuit. You may be able to say that the American with Disabilities Act says you can't do that to me. But in the instant time, but in the minute that you have to make that decision, your lawsuit is really only conceptual, and it doesn't accrue until you have that damage. And so that means that you have to suffer a damage in order to maintain any type of litigation. And it's a long road there. And so the advice is if you are not vulnerable, if you do not need a reasonable accommodation, or if you can find a safe way to perform the duties of your position, then you need to do that. If you do believe you're being discriminated against, if you believe that you have every right to a reasonable accommodation, well, then you make your reasonable accommodation. The reasonable accommodations are made in writing, and you've seen these forms go back and forth from employer to employee. There is supposed to be a back and forth or an engagement between employer and employee as to how to frame the reasonable accommodation. And so it starts with the request. And so if you do want to pursue a reasonable accommodation, particularly one where it prevents you from having to be exposed to COVID because of a vulnerable medical condition, you need to do that in writing. Any questions about that? Okay. We're going to move on to the last. Oh, Lisa's back.
Yeah, we got a question right when you said any questions. If undue hardship is a loophole for the school districts, what recourse do educators have, particularly during COVID?
I agree. Good question. You ask the teachers in the city of Decatur. They protested. They organized. They used the power of the media in order to make their statement that they were not going to return to an unsafe work environment. You can contrast that with some other areas where teachers weren't able to do that, and they didn't have that option, and still were left with this impossible decision of, do I go back to work in an unsafe environment or do I lose my job? Really, the best advice I can give is that you want to, if you're going to engage in the accommodation and the denial, you want to document that. You want to make sure you do it in writing, and then you want to seek out legal service or legal support for it. Otherwise, I believe it's a campaign of public information on behalf of teachers, such as we've seen in Metro Atlanta, where they were able to convince superintendents and school boards not to reopen yet because it wasn't safe, and to delay that. In other places, teachers were able to convince through public education, through organization, and through the media that if they were required to go back, that the environment should be made safe with masks and social distancing. Those were effective, and I know it's kind of a unsatisfying answer to hear, oh, I'm supposed to go organize and protest to do my job, but these are the times that we have, and just like I started, the tornado is swirling all around you. You are a classroom teacher. You do not have much say by yourself in how this is going to finish. But when you organize, like we've seen in several areas, at least you have a fighting chance to get policy changed. And we've seen it change in a few specific circumstances. So that's as good an answer as I can give, Lisa. And we can segue now to our litigation efforts, because GAE teachers were not alone. The national organization, seeing the inequity of this, seeing classroom teachers being exposed because of their livelihood to unsafe work conditions in a state where there really isn't a claim for unsafe work conditions, filed a lawsuit. And GAE versus Kemp, GAE raised claims against the state. And so this is a statewide class action lawsuit that sued both a local school district and the Department of Education. So Richard Woods has been sued and Governor Kemp has been sued for the failure or the abdication of responsibility to create a safe educational environment. The adamant refusal to implement COVID safety measures that were required by the CDC, and I should say suggested, because the CDC can't make a school district do anything. But a school district, in the face of those CDC recommendations, that has said, we will not require people to mask because it's not feasible, but we just will not, and we will not require people to socially distance because it's not feasible. They have been subjected to these claims of, one, creating a public nuisance, two, failure to provide adequate education for the students of Georgia because the environment isn't safe. And so that case will have a statewide impact because of the litigants or the defendants that NEA and GAE have chosen, and it's now pending in Fulton County Superior Court. I think it's an important case. The case has been litigated by tracking the CDC recommendations and tracking the impact of reopening schools, particularly this case is Paulding County School District, and reopening Paulding County School District without imposing safety measures, and seeing what there's a direct correlation between the lack of safety measures and the COVID cases that developed in schools over that time. And so it's very interesting to see what the court will do with it. It's now being in the preliminary stages. There have been motions to dismiss filed by the school district, and there's a motion for an injunction to be ordered by the court on the school district and the state filed by GAE and NEA that will be heard once it's fully been briefed. Do you have a question, Lisa?
Yes, we do have a question, and I think it's going back to the reasonable accommodations. It says, will this apply after COVID, requesting reasonable accommodations with ADA?
Of course. The ADA has existed for now 30 years, and it will continue to exist and protect employees' rights, particularly those employees who are qualified individuals with a disabling condition. The reasonable accommodation has always been on the books. It's only come to the forefront because everybody needed it so quickly. And so you always have your right to reasonable accommodation. If you have a disability, you want to go to HR, you want to document that with the medical information that's necessary. You don't have to give them your entire medical file. You only have to show them the amount of medical information that's necessary to support your position that you are a person with a disability and the accommodation that's necessary. And that usually looks like a letter from a doctor or recommendation of a treating professional. Great. The second case, COVID-related case that we have filed and worked on is actually, it's a pretty involved case, and it's very interesting, at least to me. But what I'm most proud of is that GAE was able to move quickly and was very responsive to the needs of our membership in Fulton County when they filed a lawsuit on behalf of teachers when the school district was offering a benefit during virtual learning where teachers were required to be on site, but the instruction was still virtual. The district said, you can bring your child to school with you so that the teachers could come back to work. The district knew that if they didn't give them this benefit, they wouldn't have any teachers able to come back and come to work. And so they said, well, we'll call it a benefit. You can bring your child with you to work. Your child can sit and do virtual instruction while you provide your instruction to your classroom. All you have to do is sign this waiver. And this waiver, which essentially means that you give up your rights and you are agreeing that you will not enforce your rights. This waiver covered almost anything that could have happened in school, not just to the teacher, but also to that teacher's child. And specifically for teachers that had children with disabilities that were receiving special education, it sought a waiver of that child's special education rights. And so GAE advocated for the teachers in Fulton County, wrote a letter to the school district and said, we'll sign a waiver that we won't sue you for pandemic related events. So if somebody came back to the building and got sick because of COVID, or their child got sick because of COVID, we won't sue you for that. And that's a reasonable position to take. The school district simply dismissed us and said, you'll sign the waiver or you won't get the benefit. And in fact, gave it no consideration at all. The result of that was that GAE filed a lawsuit on behalf of a class of teachers who are educators in Fulton County that have children that were trying to access this benefit. One of the plaintiffs that's in the case had a child who, because of this requirement that the teacher parent waive all the rights and she wouldn't do it, the child couldn't access instruction at home. He had to go with his father, and his father was a freelance mechanic driving all over Georgia to provide mechanical support for cars. And this poor child is trying to access his instruction on a laptop computer in the passenger seat of a pickup truck. And so that lawsuit was filed. There was a motion to dismiss filed by the school district. That's now been briefed, and we're awaiting a decision from a judge on that preliminary or that first dispositive motion. Again, that lawsuit's very specific. No, it's a narrow population of members who are working in Fulton County and had kids, but it shows the commitment to battle these types of what I think to be very onerous and very heavy-handed decision-making on teachers that's done by school districts. It empowers our teachers and lets them know that we have somebody fighting for them. And that's what we did in that case. We'll finish up with our last case, which is Barnes versus Bearden. It's a success story for GAE. It was a long time in coming. It's not over yet, unbelievably. It's not a COVID case, but it was an effort by GAE to restore the tenure rights to teachers working in school systems where the district had converted from a traditional school district to a charter district, and in doing so had waived all teachers' fair dismissal rights. The case was filed and immediately dismissed based on another decision that had come out of North Georgia that said that was completely appropriate. After bouncing around from court to court, GAE was supported by NEA's lawyers, finally had their day in front of the Georgia Supreme Court, who ruled that, in fact, that is a constitutional issue that has to be heard, and that this case up in North Georgia doesn't just dismiss this out of hand, but that these teachers have a true constitutional question, and that question needs to be resolved by the courts. And so we are now in the middle of resolving that question back in the trial court, with hopes that we will get a trial court, a hearing and a result to say that it is against our teachers' constitutional rights to take away their Fair Dismissal Act rights retroactively, or by just simply switching to a charter district in mid-run, right? So these teachers had their rights, we switch to charter district, you lose your rights. Well, you earned those rights, and those rights are valuable to you, and it shouldn't simply be retroactively revoked because a district needed to change their type of governance. And so that's the litigation efforts and a little litigation update from me. We've been talking about your federal rights. Remember, you have federal rights, you have state rights, there's regulations and there's rules. If you have a question about about something that's happened in your district, I recommend the first place to look is your handbook. The second place to look is the board policies, and then you can start to look at state law. But GAE Legal Services, again, like we talked about, is there to answer questions and provide our members support in the case where they have been treated unfairly or are now having to defend either their job or their certification.
Okay, thank you so much. We have about 1 minute. So if anybody does have any more questions, if you put it in the chat. Thank you so much for that presentation. That was very informative, and I think we all learned a lot. And I'm not seeing any more questions. So I will thank all of our members for participating this evening. And oh wait, now we get a question. If you have medical documents, FMLA, etc., do you still have to follow the district rules regarding working in the building versus at home without pay?
Medical documents. Oh, thanks, Kimberly. I'm going to answer Game Mom's question. Medical documents, You got to follow the rules. Yes, the answer is you got to follow the rules. If you feel like the rules are not being followed for you, meaning that you've shown documentation that you are entitled to work from home, then you need to let the district know that by following your grievance procedure and raising your claims under the ADA, or raising your arguments under the ADA, saying, I have my medical documentation. The district needs to provide my reasonable accommodation. And if they can't do that, then they need to tell me why.
Okay. Byron has his hand raised. Byron, you have a question?
So yes, we're both, my husband and I, we're watching this together. How y'all doing? So we're both educators. Great presentation. Can I go back to the issue of DLPs? Is that okay? Can I ask a question about the DLP?
Sure.
Yes, thank you so very much. My question about DLPs is this here: if you have an IEP, why couldn't there have just been an amendment to the IEP to include any information that needed to change? Why did we have to create another document for teachers to use? Even though you were saying the district could do that, was it a necessary compliance that took place is my question.
I think that the DLPs were a reaction to the Department of Education statement about, well, you're going to need to provide special education. You need to come up with a way to do that. And I think that, and I don't have the inside baseball on this, but I'm pretty sure that they were given directives onto how to do that by using a separate plan. I agree with you. The IEP should be the IEP, and we could
exactly.
Why are we making it so complicated by switching?
Right, because we could have amended the IEP to include any other information that was in there. We could have definitely amended the IEP to include information, because we really cut and copied from the IEP to create a DLP. So I found that a redundancy and not understanding why that was even truly needed.
I think the Georgia Department of Education did that, but I agree with you. The
Thank
IEP,
you.
DLP is essentially, so if there was a behavior intervention plan in a kid's IEP, that's the same thing as a DLP. It's like another section of the IEP.
Right. Thank you.
All right. Thank you. Any other questions? If not, once again, I'm going to thank Mr. Goodmark for being here with us this evening. It was very, very informative. And I will let you know if you want to go back and watch this again, you have more questions. This will be available on the GAE YouTube channel. And of course, we will have the link in our next member alert. And we are planning, we will be continuing Rights at Night. We're not sure right now when the next session will be. We had thought it might be later this summer, but then I had another question from several members that we may go ahead and do next month. So watch your member alerts, watch your email, and thank you all for joining us this evening. Have a great evening.
Good night.